The next matter to come before the court this morning is Orians versus Ellis. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, if you let me know when you get started, I'm keeping the clock this morning, and I can keep you apprised of the passage of time if you wish. The court's read the briefs, and we're ready to proceed when you are.
Good morning, Your Honors. My name is Attorney Connie Hightower, and I represent the appellant, the mother Shanen Orians in this case. May it please the court, I'd like to reserve 3 minutes for rebuttal, please. Your Honors, I'd like to provide just a very brief statement of the facts. This case is not necessarily fact-specific as to what has occurred between the parties, but more fact-specific as to procedurally what occurred in this case. I think one of the things to understand is that there's a divorced parents, mother and father, with 3 children. Mother was living in Canada with the 3 children as a result of court orders that occurred in 2013. The mother and father had divorced in 2008, and as a part of their dissolution, there was no shared parenting plan. There was legal custody given to mother, and father had visitation rights. The children had always lived with their mother, and they had been operating off of the 2008 divorce decree until motions began being filed in 2013 and again in 2014. So this comes to 2014, where in July they had 2 hearings based on the same issue. Various motions, but mainly father's motion for reallocation of parental rights and responsibilities. As a result of that, on August 19th, the magistrate issued a temporary school placement of the children order, which required that the children would attend school from father's home. Didn't change custody, didn't say that mom could not have the children live with her or have them attend from father's. Maybe mom may have wanted to move and come back here temporarily, but it didn't change any custody, didn't make any determination. It was just merely a school placement order. Mother filed a motion to set aside on August 22nd. On August 2nd, the judge...
Excuse me, practically, how would that work? You're making a distinction here that all the court did was say the children they could live with mother, but they had to go to school in Akron or wherever, correct?
Yes, Your Honor. Practically, it could be up to the custodial parent to make that determination on how that would be made. What the court did was the court did not make a ruling on the ultimate issue in the case. The magistrate's order said that the children shall attend school from father's home. Other than that, the court was silent on anything. So it would then be up to the custodial parent to decide what arrangements, if any, she could make to make sure that she adhered to the court orders, assuming, of course, she didn't get a stay. So
she could have come and rented an apartment so that the children could attend school under the new...
She could have. Yes, she could have, or she could have made arrangements, perhaps maybe even with father, where maybe she'd come down here for a week and, she'd still be the custodian. Maybe she'd come down for a week and spend time with the children. Maybe the father would. But either way, she still maintained custody at the time. The mother filed an objection or a motion to set aside that magistrate's order. Court denied a stay on September 2nd. So the judgment entry that is an issue, or the order that's an issue in this case, is the court's order of September 4th, 2014, wherein there was no temporary language, and the court said that father would be the legal custodian residential parent of the children. And that is the basis of this appeal. We raised 2 assignments of error, that arbitrarily changing custody of the children was an abuse of discretion, and that the court's actions in arbitrarily changing custody of the children violated mother's due process rights. The appellee seems to have raised a question of whether or not there was a final appealable order, which seems to me to be the crux of this. In the appellee's brief on page 2 and page 5, he concedes essentially that if these were not temporary orders issued by the judge, that he would see that our arguments have merit, and that the judge has a right to temporarily change, but he would see how it could possibly be a violation of due process rights. That's the quote on page 5. On page 2, he did say that he could see how, if it weren't temporary, there could be an issue with it being an abuse of discretion. So as far as
the court's order did not explicitly say, use the word temporary.
Correct. the court issued on their order of 9/14/2014, the court said defendant shall be the residential parent and legal custodian of the parent's minor children, and then listed the children, and never said it was temporary, did not use any language which would imply that it was temporary, and also included the pursuant to Civil Rule 58B language at the bottom, which would show that it's a judgment. So the question that arises in this case is if you have an order which makes a finding that expands what the magistrate's order said, magistrate's order didn't address custody, and includes a paragraph which addresses the ultimate question in this case, giving custody to father, then what occurs after that? If you don't object or you don't file an appeal, then that order goes into effect and effectively changes custody. There's no qualifying language that says until further order of this court. So it is then ordered at that time that the custody changed. Father was then the residential and the legal custodian. Mom had no visitation rights in this order, no child support rights. It substantially affected her right to be able to parent her children or to be able to make the appropriate decisions regarding her children. And so that essentially is where the abuse of discretion as well as the due process arguments come from, because with an order that arbitrarily makes this change, the court didn't have any transcripts. The only thing that was attached to the motion for stay was Mom's affidavit and the joint stipulations for the party. So there was no evidentiary basis for the court to be able to make a change of custody, but that's exactly what happened. And so at that point, you're between a rock and a hard place. If there's no mechanism for questioning to the court to clarify an order, but if the court says, this is what shall be, doesn't say further order of the court, doesn't say temporary, subject to appeal, because it's an error, and that's exactly what the mother did in this case.
Well, the opposing counsel indicates in its brief that the court did have access to the transcript at the time. Perhaps I misread that, but I thought that I read that the argument was that the court did have access to the transcript.
Your Honor, I didn't see that, and we did not receive the copy of the transcripts until at least 2 months after this was filed. The objection was filed on, the motion to set aside was filed on August 22nd, and the judge ruled on the 4th, and then Mom still, the court reporter still had to do the transcripts, and Mom had to pay for them. So I don't believe they were done by the time that order came out. In fact, I'm almost positive they weren't done by that time.
Okay. Go ahead, I'll try to find it. Here, the transcript has been available since November 24th, 2014, when they were filed by the court. So that would have been after the time.
Yes.
Okay.
And Your Honor, I believe that leaves me about 5 minutes for the trial. 7.5 minutes. Okay, well, I'm going to take 2 more minutes then. I think my timing was wrong down here. We addressed abuse of discretion. I think change of circumstance. There was no change of circumstance. There was no notice and opportunity to be heard. One of the reasons why we're bringing up due process rights under the 14th Amendment, which extrapolate from the 5th Amendment as it pertains to state actions, is that there is a reason why parents are given notice and opportunity to be heard before custody is changed for their children. That is evident in Troxel v. Granville, where it includes a substantial component that provide heightened protection against governmental interference with these fundamental rights. And this is what we're opposing at this point. This action and how this action occurred fundamentally interfered with mother's right to parent her children, to be a parent to that child. And there was no mechanism, no further hearing dates, no anything set after that point.
And perhaps on your rebuttal, you can answer the question of why this issue is not moot at the present time. I know you're running out of time now.
I can answer that question, Your Honor. I just want clarification of why it's not moot. The trial court issued a magistrate's decision, and the judge issued a judgment entry. All of the proper objections were made, and this court found that there was no jurisdiction for the judge to have entered a judgment while appeal was pending, and vacated that. So it is not moot because the magistrate's decision and the judgment entry were essentially invalidated by this court.
Good morning, Your Honors. Attorney Ron Gatz for the appellee, Thomas Ellis. I know that the court's read the briefs briefly, that originally the magistrate's order on August 19th specifically states that it's a temporary school placement. And it doesn't say that, it says that the minor children shall temporarily attend school from father's residence for the 2014-15 school year until further order of the court. Essentially, that's granting father some type of temporary legal custody. The magistrate doesn't order that specifically, but counsel has argued that mom had the opportunity to then move herself back to Akron. The children would then be able to go into father's school district, and that's not what was ordered by the magistrate. It was specifically that the children would go to school from father's residence. This was issued in order to get the children into school. There was insufficient time for the magistrate to order her final decision before the start of the school year. The other point is that they argued that this was not, that the judge's order didn't say anything about pending further order of the court. Well, we already know that there's pending further order of the court because the judge's September 4th judgment entry is specific to overruling only the motion to stay, not their motion to set aside. The motion to set aside was still pending at that time, and as such, the judge's order dated September 4th would have been a temporary order. The fact that it expanded the magistrate's order or reworded it, I think is irrelevant, but I believe that that's what the opposing side is making such a big deal of. The court later issued another order saying, just so that it is clear, those prior orders are temporary in nature and only dealt with the stay, not with the ultimate issue of mother's motion to set aside, which now, as I believe Judge Whitmore had asked whether or not it was moved, the court had then issued a full decision in the matter. So I guess whether mother is right and that that the judge didn't have a right to expand the magistrate's decision, you will send it back to the trial court. The trial court will then reissue that magistrate's decision, and we're going to ultimately, I think, be back here anyway. But I think that it is moot. I think that it's, quite frankly, a waste of this court's time that we're here because the trial court specifically stated they were temporary. So those are what I see to be the issues, and I have nothing further unless there's questions from the court.
Thank you.
Thank you, Your Honor.
There's a few things I'd like to clarify. First, the argument is not that the children could attend from father's school district. I think I was very clear in saying
I'm sorry, from mother's school district?
From father's school district.
I thought he said that it was intended that the children attend school from his residence.
Your Honor, I can't say what was intended. I can only say what the order said. The order said, yes, the children shall attend school from father's residence. But I believe that opposing counsel said that we said it was merely father's school district, and that was not what I had said to the court. Just wanted to clarify that they could still attend from father's residence. Mom could still be here functioning as a custodial parent for those same children. As to the specifically overruling the motion to stay, on September 2nd, the judge actually did an order denying the motion for stay. This order 2 days later came out, which did readdress again the motion for stay, but then did include the language that father was the custodial parent with no qualifying language, legal and custodial. Opposing counsel also mentions that there was some rewording. Actually, the wording in the judge's order was completely different than the wording that was in the magistrate's decision. The judge had said that the magistrate had ordered that the children, I believe, requires the plaintiff to return the minor children to Ohio where they are to reside with defendant pending further hearing. That's number 2 of the judge's order. That was not said in the magistrate's decision. That was a completely different statement. It's not a rewording. It's completely different finding of fact. As far as the court clarifying those temporary orders, the court issued an order while this appeal was pending, clarifying that the September 4th order was a temporary order. At that point in time, the 30-day appellate period had expired. Mom had timely filed an appeal and had already put on the record what the basis of that appeal was and had done a couple motions for stay. So at that time, the court was issuing an order where this court had found they didn't have jurisdiction to do, so they issued first one they didn't have jurisdiction to do, then the magistrate's decision came out, and then they issued a second one they didn't have jurisdiction to do. And so this is why it's not moot and it's not a waste of the court's time. If a party observes their rights and files an appeal, they have the right for this court to hear an appeal, not for orders to come out that are either correctively changing some terms that were made for the order that was brought to this court, or resolving the final issues of this court before this court has done so. Thank you, Your Honors. We ask that at the conclusion of this, that you will reverse and remand this case back to the trial court. Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision, which will be mailed to both sides as well as posted on our website and the Supreme Court website. Thank you.